First of all, last time that I spoke about ribis and the possibility of a haramis or a mutters or a not mutter. I'm not going to repeat all of that, but I want to draw your attention to a English sefer that I came upon since then, written by Rabbi Daniel Feldman, who was one of your predecessors in this room. It's on Haram. The title eludes me. It has to do with Haram in general, and there is a comprehensive section on Haram with regard to ribis, citation of a plethora of sources. Despite all of that, I stand on what I said last time. Uh, there's, of course, there the differences of opinion, but I want to try to give a comprehensive view of Haram B'chlal and as it works out in Hilchos Ribis in particular. But partially, I'm not quoting. It's my fault. It's my fault because I wrote an article that appeared in volume 6, I believe, of Contemporary Halachic Problems, which I probably gave the wrong title. I gave it the title Heter, Iska and American Courts. That was kind of a bait and switch. Heter, Iska and American Courts, you can't make Birkas HaTorah on, but the introduction swallows the article, and the introduction deals with Harom in particular, as well as with a number of other things. That's not the first time I wrote about Heter Iska. There are Nuschoyes of Heter Iska in volume 3, I believe, if I'm not mistaken, and a short cursory discussion of either one or two. In any event, I'm going to talk about the Nuschoyes of Heter Iska, as well as various forms of Heter Iska, in addition to the two that we spoke about last time. Last time we spoke about the Heter Iska, the Rama Victors, and then the Heter Iska of the Chachmas Sodom, why it was changed, how it was changed, and there are other types of Heter Iska floating around out there, some of which are included in my volume, some are not. However, I have a brand new Maram that's hot off the press. It comes from a certain magazine called newspaper, Hamidia, the weekend edition. The Hamidia Prime is called, and it's dated Zayin Tishrei Yom Kippur. It's kind of a steer of Neubei. Can't be Zayin Tishrei and Yom Kippur, but that's what it says. Now, in this, there is an article dealing with identifying interest by an outfit that calls itself the Beis Din Tzedek Liyonei Ribis, and it's got some things that are interesting. I'll share one of them with you in a moment, and then I'll say whatever I have to say about the rest of it. But it's got kinds of interesting information, including things that might not occur to anybody. As long as we're talking about things that might not have occurred to anybody, it's so obvious to me. It's this last Sukkot. I was sitting in the sukkah with somebody. I can't say he was a Rabin Shakob Neagela or Pakish Mebehiroa, but he was far, far from Amoritz. He was a Gavir. And the Gavir tells me that they're now springing up all over the place, at least all over the place. Flatbush, Borough Park, Lakewood, these mega grocery stores, which cost a lot of money we have to invest. This fellow apparently decided that he's onto a good deal. So you have to borrow money to do things like this, big money, and apparently not everybody can get all he needs in the bank. So he went and he offered somebody a sizable loan, which would be revolving, and the loan will be repaid as he buys in the grocery store. He'll take it off the bill, but he wants the 10% discount. It's nicht eingefallen that there's a Shaila Rivers involved. Course, it didn't occur to him at all. Okay, fine. I don't know how to get around that so easily, but I have something else here. There's some things here that I'll talk about in a second, but there's one that struck me very well. It's here, a little item, I think it's on page 16. If I have the right one. Yeah. This can also be between a father and a son, and I'm sure this has happened to everybody in the room who's a parent of more than one child. Since they live on two separate accounts, this is considered regular ribbis, just like any of the two individuals, etc., etc. Next paragraph. Another old classic scenario when a child comes home from avos ubonim with a half-eaten snack, and his young sister also wants. She starts crying, and the father doesn't have the koyach for her. So what does he do? He tells the son to give her the snack and what's left over, and he'll buy him another whole snack tomorrow. I'm sure it's happened to everyone. I can't. My children didn't go to Visible, but this, I'm sure the same thing happens all over. Is it ribis shumanar mumchim? I leave it to you to decide whether it's ribis or not. I see two studim here. To me, yeah, it's obvious it's ribis. You don't have to be very often to figure this out. I take giving you a half, and I'm giving you a whole. The other side is, it seems to me that the father is not being shabbat himself to give a whole snack tomorrow to the child. And if the child would summon him to Bezdin, the first thing the father would say was, "This is all part of Tsar Gidel Bonim. I wanted to get the other kid to stop crying." Or if he's really a good father, he'll say, "I did this to be machanech the child. You have to learn how to share snacks, and then you have to train the child that lo yafsid. You share snacks, or Bnei Shalom will give you, and I'm your shliach to give it back to you." That's all I meant. I didn't mean anything else. Is that, or is it? Kind of Talmid Chachamim are makbidim zelzeh. I know if a ben isn't makbid, I'm noted lahatir. But what really got me was the next line. This is ribis deraisa. How it can be ribis deraisa, I haven't the vaguest idea. There's certainly no shibu. There's no tzitzis tomim. There's no agan. It doesn't. That part doesn't make sense. But no, I leave that to you. You can analyze it to your heart's content. I mean, the shaila in the case in the real world, it's a shaila. I'm not so certain I'm right, but that's beside the point. What I have here is something else that I want to draw to your attention, and that's, to me at least, it's a worse error. He talks about things that have happened, and one of them is very, very close to something that happened with me personally. He talks about a person who wanted to enter into a mortgage agreement with Alpi Heter Iska, and it's a Jewish firm, Machzor Shlish or I don't really know, but he wants a Heter Iska, so he calls and he asks, "Do you have a Heter Iska?" And they tell him, "Yes, we have a Heter Iska." So he says, "Send me a copy." No, you can't send your copy. You have to come and look at it in the office in downtown Manhattan. He lives, who knows where, in Oshkosh. They know very well he's not going to come look at it. But apparently, I had to write an article. Or he's the best, and the only group is. So he went and he looked. And guess what? Upon arrival at the bank's central office in Manhattan, he was shocked to see at the bottom of the contract the words, quote, "This Heter Iske cannot alter anything stated in the contract." Close quote. Now, he proceeds to tell me, another sentence comes afterwards, "The U.S. court system does not recognize Heter Iske. The first paragraph was wrong, and the second paragraph is wrong. The Heter Iske in American court was designed to show that Heter Iske, when it's written and drafted and testified to by an expert witness who knows a little bit about Dine Ribis and Heter Iske, is absolutely enforceable in an American court. The contracts are enforceable as a matter of a constitutional right. A Heter Iske is not pro forma, it's not what Moshe calls halachash, which sounds like some kind of ritual incantation or who knows what. But I'll put more, and whether it's enforceable or not is less of a problem. I'll come to that in a second. But the clearly, if you put into a heter iska and nusach that says, but anything that here says heter iska isn't understood, it means something else. It's a steer minay obey. What do you want the court to do with this? Now, I'm not going to talk about the second part of the article, is enforceable in American courts. It says simply that, yes, it's absolutely enforceable, constitutionally protected. You don't have to be a Jew to love Levi's rye bread. You don't have to be a Jew to write Heteriska. An Italian can also write Heteriska. Indeed, if you know some mafiosonik who's afraid of being prosecuted for being a loan shark, send him to me. I'll write him a Heteriska, and it'll work. At least the first time in court. Afterwards, I'm sure the legislature will find ways to plug it. So maybe it's not a good idea to share it with people who don't need this information. But a heter iskit properly drafted is absolutely enforceable. You'll show me a whole string of cases where the courts didn't enforce it. Sure, because you get an idiot who gets up on the witness stand and he established himself as an expert in Jewish law, and you ask him what's a Heter Iska, and the first word out of his mouth, first sentence is it's there as a trick, a means of avoiding interest. Tell the court it's a means of avoiding interest, and you're cooked. It's not what this is. You have to tell them it's a loan agreement, it's a chatzi milch, chatzi cotton, it's an investment agreement, whatever you want. The earliest case goes back 40 years, 50 years, Leibovicki versus Ravovicki. It was some Yidel who decided he wanted to charge a usurious rate of interest, so he made himself a Heter Iska. And the Bleich didn't want to pay because a usurious contract for repayment of a loan is not enforceable at all. You can't collect a Karen either, BDNAM, because it's an illegal contract. And the court took a look at it and said, this isn't a loan agreement. This is an investment agreement. There's no limit to what you can charge on an investment. He's a nice guy. He's sharing his profits with you. He took only 14%. Today, 14% isn't usury anymore. And that's since the credit card companies got into business. But then it was. That's what he wants, an investment contract. He may not have to pay anything. He will work on the merits. If you look in all of the other cases, you'll see that either there's something wrong in the way it was drafted in the first place and the court couldn't figure it out. If you take a rubber stamp and you write Al pi heter iska and stamp an ordinary loan agreement, don't expect the court to be able to read Al pi heter iska in Hebrew. And if they do, he'll say, who's heter iska? The Merama Victors, the Chochmas Sodoms, or Bleichs. Or somebody else's. There are other people out there who have heter iskas. So if you're now there are chumras out there. Somebody now the new rubber stamp, Al pi heter iska the Maram. He takes out that just because Maram, and I don't know which Maram he's talking about. Who's Maram? I don't know Maram Mintz, Maram Victors. It's not what you meant anyway. You meant the Chochmas Sodom. You didn't tell anybody you meant Chochmas Sodom, but you think it's the Heter of Maram. Now that kind of embarrassment is also very rampant out there. So if you don't draft it the right way, or if you get somebody to testify in court, and the guy gets on the stand and says all kinds of nonsense because he doesn't understand what Heter is himself, what do you expect from the poor court? How's the court supposed to understand it? Every case where it has been properly drafted and properly presented, it has been enforced by a court, at least up to the date of publication of Volume 6. I haven't checked the law report since Volume 6. I suspect the track record is still unblemished. In either event, the first thing that I want to talk about today is whether a Heter Iska has to be enforceable in the American court or whether it doesn't have to be enforceable in the American court. I began all of this when I began writing Heter Iska, assuming to me it was a kind of a dover poshut that any Heter Iska will be enforceable in a secular court, and whether it has to be enforceable by Kodesh Shalakum or not in order to avoid the Issa Ribis, I consider to be a moot question. And that was all very fine. And when I drafted the first Heter Iska, I didn't say anything about the secular court. Heter Iska, here it is, Shalom al Yisrael. Then something happened. I was asked to give expert testimony by affidavit in a case involving an Israeli diamond dealer. Now, I'm not a bookie of what's on 47th Street. But I know that 47th Street has their own Shulchan Aruch, and 47th Street has their own Pashranim. They have their own business. I have marveled, and I haven't been there very often, but I marvel every time that I'm there. I have never seen a check. Either people paying cash, and I can tell who they are because it's usually a young couple, a man and a woman. They're buying engagement rings, or they're people who look rather Jewish and nothing changes hands. I don't know when the money changes hands, but in 47th Street, you can get diamonds. You get tens of thousands of dollars worth of diamonds, and you have such a little wallet, not this different kind of wallet in which they put it in. They put it in their pocket and they leave. Sometimes with a handshake, sometimes without a handshake. And there's a rule on 47th Street, I gather. When you take diamonds like that, you can return them for any reason, for a good reason, for a bad reason, or for no reason. It seems, if you violate the rules, you won't last there very long. But they're honest people, at least on 47th Street, they're honest. I hope they're honest everybody else. More or less the same thing goes on in Eretz Yisrael, except in Eretz Yisrael, they came up with a Naya patent. Instead of just walking around with diamonds and settling whenever you settle, uh, you run off to the bank and you take a little IOU that says IOU such and such for the diamonds they bought, and you discount it in the bank. So you get money from the bank immediately. Only there is a rule, the bank's rule, the Bourse's rule, I don't know whose rule it is. You can, it's called an executor agreement. You can do the same thing you do in New York. You can return diamonds in Tel Aviv for no reason, for a good reason, for a bad reason, and nothing is owed. But in the meantime, you've gone to the bank, you've discounted in the bank, and the bank is left holding a piece of paper. And obviously, if I don't, that's the seller. The seller, nobody owes him any money. What he sold to the bank is a kind of a fraud. So there is a rule, a general rule. The general rule is, I forget, it's a rule in Israel, it's a rule here, except there's a little knach here. The rule is that if you have an executory agreement and you have an IOU or some other instrument that is negotiable, you cannot cancel it without notice to the party who has received it. You have to give notice, only fair, isn't it? So this is a gentleman. He was the father of somebody who, Seligman, his name was, if I remember. His son was the executive director of the late unlamented Synagogue Council of America. He was apparently a diamond dealer, seems to be a man of means, because this is in the mid 80s, the bottom fell out of the diamond market. Some people in the room can remember, other people don't know what diamond markets are altogether. And no, there's no reason why they should. But if you knew anything about what was going on at the time, in some circles, this was a catastrophe. Diamond dealers were virtually going bankrupt because they bought stuff and the schayra wasn't worth anything. You couldn't sell it anymore. So Mr. Ziegman had borrowed money from the bank. His diamonds aren't worth anything. He returns it to the seller, and the bank wants to collect. But the bank can't collect the money it gave him because he gave him a lot more than the diamonds were worth, and they don't even want to go back to the seller to get the diamonds to the seller because they'll still be left holding the bag. So Mr. Ziegman apparently is not a poor man. He is being sued in a New York court. He has assets in America. He's being sued in a New York court, and his defense is Heter Iska. The Israeli banks all have a Heter Iska. I'll talk about their Heter Iska in a moment, at least briefly. They have a Heter Iska, and his defense is that there's a Heter Iska, it was a joint venture, and he returned it, and this is what the deal was originally, that he has the right to return it. And he presents an affidavit from somebody by the name of Chaim Cohn to the effect that was then a retired judge of the Israeli Supreme Court. Chaim Cohn, in case you don't know who the name is, he learned in Hebron for a couple of years. He was German, came to Eretz Yisrael in the 20s, I think, and he contributed articles in Encyclopedia Judaica on Jewish law. He occupied the Jewish seat on the Supreme Court at a certain point. He also had the distinction of traveling, Cohen, he was a Cohen, he traveled from Eretz Yisrael to Long Island and had a non-Orthodox clergyman officiate at his marriage to a Grusha. But huh? Shofet Kohen, yes, Chaim Cohen. Yeah. I mean, it wasn't Bar Kodesh. It was, I don't know if they were sharing or not. That's beside the point. But he went off to Los Angeles, sorry, to Long Island, to marry a Grusha because he couldn't do it in Eretz Yisrael. Don't you understand what's going on here? And instead of Cyprus, he came and he writes an affidavit saying that if I were still sitting on the court, I would throw it out just like a heterisk, just like Mechiras Chometz. It's all a haroma, it's a subterfuge, And he throws in for good measure the chutzpah of the man to plead Heter Iska. It's an accommodation made by the Israeli banks because of religious scruples, and now they're taking advantage of the poor Malva, and they're trying to pull the wool over as the American court. He used exactly as these Lashonis. It's a harama like a Heter. I would throw it out, be garnished. Nothing. It's nothing worth it. It's not worth anything. So he presents an affidavit, and somebody asks me to present a counter affidavit. So I wrote an affidavit saying Heterisk is not a harama, that Mechiras Chometz is not a harama, and for good measure, I found precedent in Ottoman law that the Ottoman courts during the days of the mandate enforced that Heterisk was negation. And there's a rule in Eretz Israel, it still is, but it's modified somewhat, that if there's no Chok HaKnesset and there's no precedent in an Israeli court, you look to whatever precedent existed, blah, blah, blah. The Ottoman courts existed and their takdim was valid precedent. And I said, if I were sitting, I didn't say it in those words, that I would enforce Eteriska. There's no problem whatsoever about this Eteriska. I don't know the end of the story, except I know they went out and settled. So I presume that it accomplished something, but it had a very profound effect on me. It had a profound effect on me because part of the case was the defense against the claim, despite the fact it was a heteriska and a joint venture, was there's an arcane provision in New York banking law, or not banking law, it's partnership law. It's that what notice to a partnership, notice to one partner is notice to all partners. So you don't have to give notice to every partner. If I returned it to whoever I bought it from, so I gave notice, and I don't have to give notice to the bank because I'm a shooter for the bank, and I knew what was going on here. So we're shooting. Notice to me is good enough. Notice to them, I didn't have to give notice there. How far that would have gotten in New York, I don't know, because it's an issue of form of law. Which applies here, Israeli law or American law. There's no such provision in Israeli law. Otherwise, the heteriska would have been out long before this. But if you would ask me, was Chaim Cohen have a point? He may have had a point. This is clearly whatever Bez is going to do with this, Bez is going to do with this. But there's a loss here, and the question isn't who's chayiv and who's potter. The question is who should bear the loss here. And is it really fair to assign the loss to one party because of a technicality that there wasn't notice to him? Just because you didn't have notice, that means that you can't enforce the head risk, blah, blah. So I came up with the following idea. The following idea, which wasn't so great Kiddush, I long had assumed that the heter risk is valid and I don't have to enter into the Shiloh whether it has to be valid lahalocha. But who knows what somebody else is going to come up with tomorrow in order to challenge the heter risk in court. So I decided that I should draft a heter risk in which I put in a clause that says that this is Kedas Bleich of Yisrael, and the parties agreed to go to Beis Din to adjudicate any sichsuch, and if chas v'sholem they don't go to a Beis Din like they're mechuyev, the court will presumably order them to a Beis Din, I hope. Sometimes courts don't send you to a Beis Din, but okay, he sent him to a Beis Din. It's a problem getting to enforce the decision afterwards, but when you have such an arbitration clause, they usually send you. Later, they can come up with all kinds of reasons why they won't enforce it, which is also bad enough. But I put in another clause that said, and if for any reason this ends up in Arkoy Shal Akum, which it shouldn't, clearly it shouldn't end up in Arkoy Shal Akum, the court should treat it as an ordinary loan agreement. And I consider this to be without a problem. But I'm not an expert in American contract law. So I have a person down the corridor in another building who is an expert. He's a very bright guy, the brightest guy on the faculty of Cardozo. He's a professor of contracts. So I go to him and I show him my nusach and I ask him, is there any reason why I shouldn't publish this, use it? Is there any reason why I can't have a document which is being construed one way in arbitration and another way in the court? And he scratches a little bit, Tani the Messiah, And he gives me examples in corporate law and S corporation, which I don't even know what it is. It's one thing in American law, it doesn't exist in German law. And their contracts that are formulated, you go to a German American court, it's one thing. You go to a German court, it's another thing. He tells me it's perfect. There's no reason why he can't do it. And then as I get up to leave, he says, but I caution you, don't rely on a justice of New York State Supreme Court, which is the lowest court, to understand what you're drafting. They're too stupid. Yeah, I mean, the New York State Supreme Court, that's the lowest courts, the appellate court had a better reputation. They did not have a very good reputation in academic circles, to say the least. It's not my business. What do I care? But he's warning me not to do this because I'll only confuse the judge. He won't understand this. Okay. So when I published the Nusach in volume 3, I left it out. Then, after volume 3, came this business with Ziegman, an Israeli discount bank. And I realized that it's not such a good idea because maybe there's sometimes when you don't want it to be enforced in the secular court for whatever reason. And why can't I go back to what I think is correct and proper? Put in a clause to go to Besdin. You don't go to Besdin, then you go to court. I don't care what happens in court. It's not my business. And I already published volume 3, so I appended it to volume 6. There's a long paragraph that is to be appended to the Heter Iska that I drafted elsewhere. If you're going to use it in court, and you can put the two together so that you can get the best of both worlds, maybe, where you get two bites out of the apple. I'm not quite sure which it is. Either way, that's not what I want to talk about. That's practical. But what I do want to talk about are two things. Number one, the basic shaila. Does a heter iska have to be enforceable in the American court, or doesn't have to be enforceable in the American court for it to be valid in Dinei Yisrael? Problem number one. Problem number two that I want to talk about are different nuschois of heter iska, different ways to construe heter iska, because it's not the case that one size fits all. There are cases in which a heter iska, obviously, the standard heter iska will not work, even if you draft it completely. Even if you draft it correctly, so therefore you have to find ways of working around it, drafting a heter iska that will work in arcane situations. Now, this is not a new shaila by any means. Do instruments have to be valid in our Kodesh Shalakim or not? Now, please do not tell me Dina de Malchusa Dina. I'm no great chassid of Dina de Malchusa Dina. There is very little enforceable in Dina de Malchusa. I know where it's enforceable, it's not enforceable. I know the Ramah that tells me where we have a Sisa Yoshavatay and Sida Malchus, you can enforce this in Malchus, it's all very nice. But Sisa Yoshavatay is also halach, it's not in the Malchus. The return of Veda after years, okay, so Sisa Yoshavatay, it's not because it's in the Malchus. Shach and Simonai and Gimel, where the Ramoy is, Kazanish, they all go out of their way to say that there cannot be a Din de Malchusa, which is Seiser Dine Yisrael. I'll tell you another little anecdote. When I was knee-high to a grasshopper, I was very young. I spoke Yiddish because I had a great-grandmother, Allah Shalom, who spoke to me in Yiddish. She practically raised me. I spoke Yiddish, but I couldn't read Yiddish. And I was 10 or 11, and I wanted to teach myself Yiddish. I want to know how to read Yiddish. She wrote Yiddish. She had letters that came to her from Landsleiten Yiddish, God knows what. And there was a periodical that came to the house. It was called Das Yiddish Wort. I think it's still around. So I took this Yiddish word and I tried parsing it out. I knew the alphabets. So I was trying to teach myself Yiddish by reading this Yiddish word. And one was an article about a Reformed clergyman who was Masader Kedushin for a grusha who didn't have a get. And he wrote a tshuva, Nochalam, to the bargain. It was all of 3 lines. Hebrew I knew better than Yiddish at the time. I was probably 11 already. And he says, he wrote it that she's muteres l'cholodom, v'tami b'dovar, dina the malchus dina. She had a civil decree, dina malchus dina. I knew already that this guy is not Moritz. And that it can't be dina malchus dina that affects Inyoni issues. maybe that prejudiced me against the Malchus for the rest of my life. I don't really know. But I know that there's Din Malchus, I call it Din Malchus, it's through the back door. I have a Shach, I have a Chazanish tell me that it's both the Mevudal for the Ara, except I know that there's the back door. What's the back door? The back door is in contract law, only we call it minig asoichrim. Minig asoichrim becomes part of a contract. It's an unwritten, unspoken condition. It's there. If everybody behaves that way, then you've got, not because it's the Balchusa, but because it's minig asoichrim. Why it became minig asoichrim is not my business. It became minig asoichrim because he treats everybody the same way. The Jews, the Goyim, the Frumah, they're not Frumah, and it's understood that that's what it is. Uh, yeah, I'll tell you another mice if you want. When I moved into the apartment, which I have now occupying for almost 60 years, it was owned by Goyim to the best of my knowledge. And 2 or 4 years later, as the, no, 2 years later, as the, 4 years later, maybe, I don't remember, there's something that was called rent stabilization. So this is long before most people in this room. There was rent control. The rent control was more or less a dead letter. Then there was rent stabilization. And lo and behold, I'm rent stabilized. But is it enforceable in the Besdin? I signed the lease that had renewal clauses long before. Did he have the right? Do I have the right to invoke rent stabilization? In the interim, the building was bought by an Erlich Yid. He may not have been a bookie in Chesed Mishpat, but I was afraid that the guy will send me a renewal and he can ask whatever he wants, market value. By then I couldn't afford market value, or better, my shul couldn't afford market value anymore. But lo and behold, he sent me a renewal clause that didn't ask for any more than rate stabilization. So then I Shiloh is a kind of a Shavas Aveda here. It's not a Shavas Aveda, that I'll leave for the separate Shiloh. He didn't realize that he could have asked for more. He thought he was bound by Din Malchusa. Was I Mechuyev to be Megal Sod or not? That's a separate Shiloh altogether. But the Din Malchusa works only when it works because the rent stabilization, if you take out today you don't see it anymore, but go back to the Hapardis, the Hamor of 50 years ago, 60 years ago. They're full of articles dealing with rent control before rent stabilization. Din Malchus isn't valid, it's not valid, and it's all this because it's Minigas Eichrim. That's one area. The other area is we're dealing with a numtana. The kind of numtana is believe kol. If everybody knows it just happens to be numtana because of din malchus, it's the marash. If there wouldn't be a din malchus, it would also be good. So you have either in din umtana, din chayse, din whatever you want, but beyond that, it doesn't go very far. So when I come to an ordinary chayv, what difference does it make whether it's enforceable as a chayv, enforceable as an investment contract? It's bound by Dina Yisrael. And what I stipulate, and who cares if it's not enforceable because they think it's a lachash or who knows what they think it is, or because they think it's a religion. The people out there, if you put a pull on a lawyer who's not familiar with a little bit of constitutional law, he seems to think that if it's a religious document, you can't enforce it. That's also not true. But that's besides the point. That's not my problem right now. The problem is there any reason halacha why it has to be valid in dine akum, or if it's not valid b'dinehem, is it not valid for us? And the only reason that I can think of has got nothing to do with dinah malchusa, because there's a numtana that they don't tend to be bound by dinah Yisrael. I'll come to that afterwards. I'm not sure that there is a one answer fits all here either, but it's not the only area in which this arises. It arises in contemporary times with the Heter Mechira of Eretz Yisrael during Shemitah, and I'll talk about that in a second. And it arose once upon a time with regard to Mechiras Chometz. In the Austro-Hungarian Empire, there was a law that said that you had to, on any bill of sale, you had to attach a tax document. Now, I don't know if you went to a bakery and bought a loaf of bread and you got a receipt that you had to tax a tax stamp to the bill of sale. If I read some of the chuvas, it sounds as if that was the law. If it was, it was. Were the bakers in violation? I don't know. Maybe they were. In any event, there was a lot of malshinim. Somebody went to Franz Yosef, Ephraim Yossel, the Jews called him. Ephraim Yossel had a reputation as being an Oiv Yisrael. And they went to tell him, these Jews, they're violating the Din Malchusa wholesale, they're tax evaders. Every Erev Pesach, every row makes the Shtar Mechira, and the Makach the Kaiser, his Hachnosa is not paying for the taxes. The Franz Yossel, Ephraim Yossel threw the Malshin out and told for reasons I'm not sure it had anything to do with Ahavas Yisrael. Bechlal, he and others like him, they were afraid of anything that tampers with religion, because religion to them was divine right of kings, and they wanted people to be frum. They didn't care what religion you had, just be frum, whatever it is, so that we're secure on the throne. But what happened was that he threw them out and says, "What do you want? They're doing this for tax purposes. They're not doing this to avoid taxes. They're doing it because there's an Isser Chometz. You know about enough Isser Chometz. It's Pesach. They know they can't own it, so they make this thing. Who cares? What's it got to do with me? If they didn't do this, they deduct the Chometz. They burn the Chometz. I don't know what they would do. It probably is too expensive to put the tax stamp on it." And to him was not a problem altogether. What Franz Josef wasn't a Shaila, was a Shaila to the Baruch Tam. The Baruch Tam wrote and wrote, and he thought that it was in violation of Din Malchusa. So what's the violation of Din Malchusa? Who needs Din Malchusa? He knew this just like I know this. And Chassam Sofer, incidentally, also. There's a Chassam Sofer, Jewish Chassam Sofer, who is slightly different Shaila. It wasn't Shaila Franz Josef, it was a different one. But he said that it's all done because you don't want to be over an Isser. And even the Goy knows this. The Goy knows that the Jew maybe steal from him anytime, but not when it comes to religion. If it comes to religion, he doesn't want to be over Bal Yeroah. The Goy, I'm just giving a lot of credit to the Goy, that the Goy realizes that the Jew will never cheat him with regard to a bill of sale, because this bill of sale is for chometz, and chometz has to be kedos v'kedin. Now, in effect, they're saying that this is a nuna demuchach. We understand that we're not bound by din machusa, because there's smichus das. There's smichus das in this, even if you don't rely on din machusa in this case. Other cases, it may be invalid in both a din, because of the fact that you can't enforce it, and people are relying on enforcing it in a secular court. That becomes now the shaila with regard to the Heter Iska. Are people relying on enforcing the Heter Iska in a secular court, or are they relying on enforcing it in a Besdin? Which is one of the reasons why I insist upon putting in my Heter Iska. Forget about the time for the Heter Iska, that it be adjudicated in the Besdin Shal Yisrael. Adjudicated in Besdin Shal Yisrael, of course I'm saying with das. The Besdin is not going to look at Din Mahus, I hope. They're not going to think that Din Mahus can invalidate it. Number one, it can't. Number two, even if it could, who cares? So it seems to me that that was another reason for doing all of this. There are chuvas in the Chassam Sofer, who and others afterwards. There's a modern day application. One of them is Rav Moshe Sternbuch. It's in the Baidim Ismanim, I think, in a footnote someplace. He was Rav in South Africa. Maybe he still is, for all I know. I don't think he's traveling back and forth anymore. But in South Africa, in the bad old days of apartheid, he had a problem with the Mechiras Chometz, because the Mechiras Chometz was to a black, and it had a clause saying that you're renting him the Mekaymes where the Chometz is being kept, and you weren't allowed to rent real estate to blacks other than in their homelands, whatever it was. It was clearly not enforceable in the South African court. So it was the same business all over again. Is there smichus das? Isn't there smichus das? In any event, Rav Henkin has, Rav Zevin, in the Laura Torah, he has whole marochis on the basic shaila in different formulations, including whatever goes on there. It's Israel during the time of Mechiras Karka. There is something else in Eretz Yisrael which doesn't exist in our country, or for that matter, in common law. Uh, the land registry systems exist in this country only since the mid 19th century. In England, they came into existence in the 1920s, if I'm not mistaken. To this day, people don't always know it. You do not have to register title in City Hall in order to get valid title. And some people, usually for not very legal reasons, don't want to register title. But the Mechira is absolutely valid, even though you don't register it. You may not have certain protections of law, which I'm not going to go into. It's not of interest to you. It's usually to your interest to register it, but you don't have to. In Eretz Yisrael, there is still, to the best of my knowledge, on the books, a law that says that if you do not register in the taboo, is botel mavutel kecheres yalma. What's taboo? Nice Hebrew word, modern Hebrew word. Taboo is Turkish. Taboo means the land registry office, and it's in the Chok. Every lawyer in Eretz Yisrael knows it. And who read you sell everything to a Bedouin, you're going to go register it in the taboo so they should be able to seize the land. They purposely didn't. And now the Shaila was, this is invalidated because in terms of Israeli law, it should invalidate it. The Mechiras Karka should be Botel Mevutel. Now they tell me if somebody want to do the research, they tell me not to the last Shemitah, but the Shemitah before, that the Knesset passed a special chok to take care of Mechiras Karka for Shemitah. I don't know what the chok says. Maybe it says this is an exception to the rule of taboo. I doubt it, because that would be saying the Bedouin should come and seize the property. I have no idea what the Knesset said. I'd be interested, but I'm not going to do the research. You can't make Birkas HaTorah on the research, and I don't need it for a footnote. But if anybody wants to do it and you find something, let me know. But it was the same problem. Is there Gemiras Das? Isn't there Gemiras Das? And that goes through all of this. Yeah, I'm sorry, Ben. Sorry?
We learned last year, we learned that not registering in taboo might be the minhag. People make illegal apartments all the time, and they don't register them in the taboo.
Eretz Yisrael in America. And they don't register them. It's big.
That way you don't have to pay any arno, no? You can just get away with it.
Okay, I just think it's been a soifrim.
That's how people argue. They were learning that today.
I hear it for the first time. I could hear better reasons. You could tell me this is not legal in Eretz Yisrael. Period. Full stop. It's only Malachi. I think that's a stronger argument. But I'm not interested in going down that road either. I mean, you've got these shilas with the air, and you can menatayach it any way you like. And who says that a minig of some soichrim is a minig all over the place? What's a minig of soichrim and meishorim may not work in, I don't know, some outlying moshav where you don't have any Shemer Torah. Incidentally, I found a tshuva in the Minchas Yaakov, in the Minchas Yaakov dealing with a Heter Iska between a Shemer Torah mitzvahs and a Heter Iska, which is not with a Shemer Torah mitzvahs. He thinks that it's not enforceable in sexual law, that it's bottled as far as a chiloni is concerned, because the chiloni, he'll go to court, and there's no smichas das that he won't go to court. So I'm not saying he's not saying das. I'm not saying das. I know that he's not saying das, so I won't be saying das. Take it whichever way you want. Whereas two from people of Ada, what's the shayla? I have to go to bed. I have no choice to go anyplace else. Whoever heard of somebody never heard of a person who puts on tefillin his choshu to go like shalakum. I mean, I never heard of such a thing. Heaven forfend. But okay, I mean that's what's mistake from all of this. So that's the first shaila is the shaila with regard to whether it has to be enforceable at all or whether it's irrelevant. There were other shilas that came up besides just the tax stamps. The shaila was even interpretation of what the law was in the Austro-Hungarian Empire. I have a friend who couldn't agree what the law was there, and again, I'm not going to do the research. There are two things in law. There's a sale which is void, and a sale which is void apol. If I want to, I can be mevatel. If not, I won't be mevatel. There was some Achronim who seemed to think that the tax stamp law, whatever it was, made the sale void abol, not necessarily void. Does that make a difference for us? It doesn't make a difference for us. I'm not even going to enter that. I don't think it makes any difference. But they were going back and forth. Of course, they were saying that if it's void, then the goy is not going to be saying mechiras chametz. If it's only void a bowl, no, who says you won't be voided? You won't go to him next year. Who knows what? Whatever. And that was that. Now, first, I'm drawing your attention to the first version of my Heter Iska and the second version of my Heter Iska, which has a clause in it giving you a kind of form of law choice. Chalila, that you have the choice, but if it ends up, and incidentally, I have precedent for that. My precedent for that is Reb Moshe with wills. Now, forget we're not talking about wills right now, but you can't draft a will, and just think that because my heirs are going to go to Bezdin anyway, it doesn't make any difference. It's kukas mishput, and it's also supposed to write a will. The only way you can write a will is if you make it tzavah, that's kosher, b'dina Yisrael, whatever way you use, and then you may have difficulty filing it tzavah in surrogate's court. Although I could give you a nusach for that also. In fact, I've done it, but that's not my problem. But there's another way of doing this, which was Ramesh's way. Ramesh says, no big problem, right? It's a halachic will, as I have termed it, and then write an ordinary will, lebitchenes. You made up the word. Lebitchenes, in case it ends up in court, you'll produce the will and you won't, you'll suppress the tzavah. What you're writing lebitchenes after you have something which is already valid in halacha is also it's ki Yehuda v'oid l'kro. What am I doing here? Of course, no, he didn't go to Bezdin. I made it tzavos. It's enforceable in Bezdin. I need the surrogate to enforce something, or I need something to be able to show the bank so I can get some money out of the account that the Meirish left to me. So of course I need something. So I did this litbitchenis. So I should be able to get whatever I can get. Or cholila, somebody challenges it in course. I pull out the will for this. It seems to me no different. If I can do it with a tzavah, why can't I do it with a will? I'm sorry, if I do it with tzavah, why can't I do it with a heter iska? Because it's there. So those are two forms of heter iska. There are other forms of heter iska that you have to use where the heter iska is of absolutely no use whatsoever. There are a whole string of cases, and you can make up some more as you go along. Cases in which I have no right to demand a shvur. Wherever I have no the accord and satisfaction, the amount that I'm paying you, being McCoy dividends or profit, is so I shouldn't have to swear a shvur that there was no profit, or that the profit was no more than what I'm paying you. We agreed that I give you chatzi mil v'chatzi pipod is the best example. I pay you 50% of all profits only if the profits are more than 20% of the face value, which is 10% of the chatzi pikoden. I get the rest. That's chartircha, whatever it is. I don't know what it is. I get all the rest because you agreed to accept less. You're not going to stand on every last fruit that you're entitled to. So you agreed out of the kindness of your heart to allow me to keep more than I'm entitled to as a 50% shutif. That's the standard heter iska. What if I know that there's been a hefset on the Karen and I can't even get the Karen back? For that, I need to aid him usually in the star. Sharing monim. And for if the Karen was destroyed because you and I know what it was invested in and it was nisrafu chutecha v'aliyah, what am I taking profit for? There's no profit. The Karen was destroyed. You know it. I know it. What's the shvur? What are we doing here? And there are cases in which that is clearly happening. We know that there is no profit. There can't be any profit. So how in the world can I use a heter iska when I know that there's no profit? I can give you a number of cases in which I know there's no profit. One of them is the simplest of all, the most complicated of all to deal with, and that is a broker's account. I go to a broker, and there are Jewish brokerage firms on Wall Street. One of the principals of such a firm contacted me many years ago and suddenly realized that he's got a heter iska problem on his hands. The client borrows money, as it were. He's buying on margin. He's borrowing stock on margin. The company's lending him the margin, and you pay it back when you sell the stock, and you pay the interest on on the margins. And they're margin calls. If the price goes down, he wants to make sure that he gets paid, so he has to put up some more money. But he doesn't want just to put up money to cover the loan in quotation marks. He wants his profit also. What kind of profit? He's got the same key, the same machine that you do. He knows that the stock lost money. That's why he's making the call in the first place. How can he demand payment of chatzi revach when he knows very well there was no revach? It's impossible. He's holding the stock. He knows nobody sold it because he's keeping this a pikotin. So what's he getting money for? Well, I think there are ways of dealing with it, but certainly don't pull out the Heter Iska maram, the stamp on it or whatever it is. You have to have a more complicated way of dealing with it. More often, and this is the mom and pop kind of arrangement, there are mortgage loans. Usually go to a bank for a mortgage loan. And the bank is a bank, whatever heter you have for the bank, you have for the bank. But there's sometimes where there's a purchase money mortgage, and that is the bank is charging 7% for a mortgage, more or less today. If I put the money that you're giving me because I want to retire in Florida and I need the income, the bank will give me 5% if I'm lucky. I'll arrange with the purchaser. We'll split the difference. I'll get a purchase money for 6%. He'll get 6%. He can't get more than 5% in the bank on a CD. I don't want to pay 7%. So we split the difference. But no money ever changes hands. He doesn't get any money. He signs whatever mortgage agreement you sign, and I know that the house is there. So I know whether the house went up in value, the house went down in value. What's the heter for the half of that for the real estate? Because it's we spoke about it maybe last time. I don't remember, but all the heterim when we don't have a transfer of cash, and one of them might be because we know where the money went, and we know whether when it may have gone up in value. For all I know, the house went up in value. I don't want to share, so the house is in Iska. That's okay until the bottom falls out of the market. It happens every once in a while. The bottom falls out of the market, and I know that nobody can get. They go get less than you paid for it. So where is the interest? Where is not the interest? Where is the reva? Where's the profit that I'm sharing in lieu of reva? What right do I have to demand it? So I have one way of dealing with both of those and another way of dealing with the purchase money mortgage. The second is probably the better one, except it may involve some kind of a haroma. The first one I think is no haroma at all. The second one I devised for the broker, and that is that the person agrees in return for the loan to buy stock in XYZ Corporation, you lend me money that I will invest chatzi mil v'chatzi pekodin b'chol esek toiv. I will add my amount equal to the amount that you're lending me on margin, and I will invest it b'chol esek toiv, like Lucky Nag that comes in an aqueduct or something of the sort. Whatever business arrangement, you don't know what the business arrangement is. I can know all kinds of business arrangements, and I can make scads of money on these business arrangements. So you're a shutif in my ASIC, and I'm a shutif in your ASIC. If you do something like that, I think it'll work, and it might even work for a student loan. Except that for a student loan, it's probably a haroma de muchach. If I'm buying stock, it's not a haroma de muchach. I can have lots of. I don't think I put my last dollar in a margin account. I don't have margin accounts. I don't have money to invest. But if I did, I don't think I put my last dollar in a margin account. I'd have money in someplace else, so I can make such an agreement, and it'll work. So it's published in volume 3. I came up with what I consider to be galat kosher and not even a harama. Read David Feldman, whether he likes aromas. He doesn't like aroma. Rav Moshe certainly did not countenance aromas. We spoke last time about other aromas that some people countenance, some people don't countenance. But when you go to the bank to get a mortgage, you don't own your house. And if you go to the bank to get a loan to buy a car, you don't own the car. Now, I know very well, I'm not such a fool. I know that you registered the deed in your name in the taboo in the registry office. I also know that the bank made sure to register its mortgage. I know that the bank has lent you the money and you have legal title. If somebody slips and breaks his neck, you're going to be liable, not the bank. And that'd be one of the reasons why the bank wants you to register it so that they don't get stuck or that the seller doesn't get stuck or who knows what. But there's something called legal title and something the lawyers call equitable title. We know who the real owner is. Don't fool me. The bank owns it. You don't own it. And what are you doing every month? If you have anybody's ever seen a mortgage agreement, you get it in the bank, you get every month in the mail, you get a statement. It says so much and so much principal, so much and so much escrow, that's to pay the real estate taxes and insurance, and so much and so much for interest. You are reducing the principal every month and you are you are decreasing the interest, I'm sorry, and you are increasing the amount of money that you pay towards the reduction of principal, and it'll tell you how much is the principal outstanding and how much interest you're going to pay this month. Next month, it'll show you that the principal outstanding is less, and the principal outstanding is reduced, and that there's less money going to pay interest on that outstanding loan because every month you're paying more on interest. I don't like to use. I don't have a whiteboard anyway. I don't know how to use it, but if you drew a piece of drew a diagram on the chalkboard, you would drill a house which has 1,000 bricks. And what's really happening is that every month you're buying one brick. First month you're buying one brick. Second month you're buying two bricks because you know what? You're paying the same $1,000. The first month you're paying $1 for a brick. You're paying $1,000. $999 is interest for the loan for the other 999 bricks. The second month, you're paying $2. You're paying actually $2 for two more bricks. So you own now three bricks. And $997 is interest for, I'm sorry, the rest is interest on the 997 bricks that I haven't bought yet. But really, what's happening here? I'm not paying you for your bricks every month. I'm renting the bricks from you. The ones that I did not buy, I'm in effect renting. You have the equitable interest, and I am in effect renting them from you. One is to prevent me from entering into a leasehold agreement instead of a kind of purchase money mortgage where all of this is going on, hocus pocus. I call a spade a spade. I'm not fooling you. I'm not fooling myself. I'm not fooling anybody. I know I don't own this house. I own one brick this month. I'll own three bricks next month. The next month I'll own five bricks. V'chule, v'chule. And every month I will be stuck paying rent on the bricks that I don't own. And guess what? At the end of 30 years, I can get full title by paying $1, or it'll pass without further payment. What I have entered into was a leasehold agreement with a right to purchase, on installment basis. I don't hear any interest here. What's interest? It's the truth. What I'm doing is actually the truth. And you know what? Give me any mortgage amortization table, and I will simply take out the headings, and where it says principal and interest, I will put in purchase of bricks or purchase of equity, and the rest will say rental of equitable interest, which is held by the seller. What's wrong with that? Is this aroma? I don't even consider it aroma. It's what's going on out there. People may want to fool themselves. So if you're fooling yourself, it's you date nafshe. But this is really what's going on in the world, only you're trying to fool yourself. So I'm saying this record straight. I'm telling you what it really is.
Would it then not be the bank's interest for a person not?
No, a bank won't do this. A bank can't do it for a number of reasons, we'll come to in a second.
Or would it not be then in the interest of the mortgage lender uh, to oppose early prepayment?
Oh, yes. he may not want early prepayment, and I may make a stipulation, I will not accept early payment. If you want to pay me everything in advance, I'll take it all from you, but pay it up front because I'm living in Florida, I'm retired, I need the rent. What if I had a rental property in New York and I was renting it? I wouldn't sell it to you. It's the goose that lays the golden egg. Why should I sell it to you? I need the rent. You can do whatever you want as long as you get yourself a good lawyer who knows a little bit about Hilchos Rivers. Yeah, it's good enough. Let me make two points were basically sidelines. One of them is just interesting, and the other I don't want to forget. The for the first is something that happens similar to this case where it shows up and it says nothing in this agreement shall be construed as varying anything that comes before. Not so long ago, every time I was in the car, there was a commercial on the radio. It was a commercial for some outfit that was in the mortgage business. They apparently were offering better rates than the bank, and I discovered that the person running this business was a Jew. And Jews were doing this. It was a good deal for them. It was a good deal for this guy. And, I was curious, more than curious. People were asking me, do they have a Heter Iska? Don't they have a Heter Iska? So I wrote a letter on Cardozo stationery, signed to the professor of law, and said there are people out there who are concerned for legal halachic reasons with regard to whether there's a Heter Iska. Do we have a Heter Iska? I get back a letter saying they have a Heter Iska. So I make a phone call asking for a copy of the Heter Iska. And I get a young lady on the telephone who speaks. I'm allowed to say this today. Is it politically correct? She spoke with a colored accent, and she had read the letter. And she says, yes, she understands this is a serious matter. It's religion. And, religion is serious, and you people take your religion seriously. Yeah, you want a copy of it? I'll send you a copy. Week goes by, 2 weeks goes by, 3 weeks go by, no copy. I call again and say, you promised to send me a copy of the Heter Iska. And guess what the answer is? The answer was, we're sorry, you'll have to come to headquarters. You'll have to come to the office to read the Heter Iska. I didn't go to the office to read the Heter Iska, but the Heter Iska that you don't want to divulge sounds very funny to me for one reason or another. But it's just the same story over again. It's the Zelba Kala, Anders Geschleyer. It's the same story with different names. That's one thing. Number two, when I spoke about whether you need a Heter Iska that's valid, Bedina Yisrael, I submit to you that no bank in the state of New York can enter into a Heter Iska that's valid, Bedina, and that's because of New York State banking law. There's a law in New York. Apparently, there's no such law in Eretz Yisrael. Why should there be? We had a depression. They didn't have a depression. But during the depression, they enacted all kinds of restrictions on the banks. One restriction is that a bank cannot have an interest in any entity to which it lends money. I never saw a more glaring violation of the banking law than this. Is the attorney general going to prosecute the bank the Israeli banks that have interests? Once upon a time, they were on display in Jewish neighborhoods, even in this country. Whether they were valid, they weren't valid. It turned out that the Heter Iska was Heter Iska from Eretz Yisrael, and the New York corporation was not the same corporation. It was a different corporation. Maybe we'll talk about corporations and Dini Ribis later, but I'm not sure that that Heter Iska was valid in New York at any point. And is there smichas das? If I know that it's not valid in New York State banking law. If I were an attorney who knew that, I certainly would advise my clients with regard to the fact that it's not valid. If not, I'm guilty of malpractice. So if you need it to be valid in Dinah Yisrael, you're in big trouble. So in effect, what I'm saying is that yes, this is not a Heter Iska. It's a loan for all purposes for all legal purposes. That means you try to enforce this as a Heter Iska in the civil court, you won't be able to. I will take the position that if I can't enforce whatever interest the government has in a secular court, that it can't be a violation of the New York State law. Am I right about that? I hope so. But I would take that position. Am I right or wrong? It's a separate issue. But I'm confident enough that if a bank were to use my nusach of the Heter Iska, it would probably pass muster, and I'm sure the Attorney General wouldn't be interested in prosecuting, which is what they're banking on anyway. But that's beside the point. So no, these are the other two kinds of Heter Iskis that you can formulate in order to deal with various different kinds of situations. Now, there are two other Heter Iskis that have now gotten into circulation. One of them, well, there are actually two of them. One of them is called the Heter Iska of Bnei Brak. Now, I don't know who formulated it in the first place, but the Heter Iska of Bnei Brak seems to me to also be Galat kosher. In fact, I think that the Heter Iska of Bnei Brak was done to avoid, well, the two of them, the both I'll talk about, I think both of them are designed to avoid the problem of the Gro. Remember that the Gro wasn't happy about the Heter Iska of the Ramo, the Marmavigders, because of the fact that the Skaramola turns out to be a peppercorn. It's insignificant. It's symbolic, and it's a haroma, Roma Nikeres. Gro didn't like that. Now, there are other ways of doing this, and I'm not sure that the Gru objected to the Chochmas Odoms, even though they're Machatonim. He didn't write a parish on the Chochmas Odom. I think that I could justify the Chochmas Odom Chatzim Mil v'Chatzim Pikodin if I had to, because if anybody wants to lend me $995,000, I'll be happy to take it from you. Give it to me as whatever you want, and I will be happy to enter into a Heter Iska with you, and I will add $5, and I don't want Askar Amola, and I will go to the bank, and what I will do is buy a jumbo CD. I don't know if they're still around. A few years ago, they were there. You get $100,000 was the magic number. For $100,000, you got more than you got for $999,995. So I only have $5. How much can I get? I can get 3%. But if I come in with a jumbo CD, I get 5%. I want 5% for my $5. It's the same ASIC to me, the same tirche, whether I sign an IOU for 100,000 or for $5. You want to give me $995? I'll be happy to share with you your share of the profits, and I keep a share of the profits. I'm not working for you. I'm working for myself. Why am I working for myself? Because I want the economy to scale. If I buy 1,000 widgets, I get a better price than if I buy 500 widgets. That's the Heter Iska of Marama Victors. I get a better price if I buy more merchandise. If that's indeed true, and I'm buying it for an ASIC, and there is an economy of scale, I don't think I need Skar Amola, even for the grow. If I'm right, I'm right. If I'm not right, so don't use this. Don't use this eights. Use other eights. But there are other eights out there that you can use. One of them that was floating around out, I don't think it was designed to overcome the girl's objection, but maybe it was. Since I don't know who wrote it, I don't know why he wrote it, and that is to make it kuloi pikodin. And we agree to split the profits. Who says I can't take a pikodin and agree to take less than the full amount? And who says I have to agree to be paid for it? I'm working for you out of the kindness of my heart. You didn't lend me anything. I'm being nice to you. I invested in Shmatis, and I made a lot of money. The kindness of my heart, you lent me the money, and I'm giving you more than 50% of the profit. That was the original agreement because I took your money. I worked for you, not for me, and you'd agreed to give me a portion of the revach. It's all scharamola. What do I have to have scharamola for? Whatever you're giving me is kuli revach. It's kuli revach because I didn't borrow any money from you. So no problem with that. That is what they call the Heter Iska b'nei Brak. There's another Heter Iska, which is now the standard Heter Iska in Israeli banks. And incidentally, part of my affidavit in the Ziegman case was that you guys are telling me that this is a Yuchaim Cohen, are telling me this is a religious accommodation. Don't fool me. I know that there was a change in the Heter Iska of the Israeli bank. The week after Rabbi Yankov Blau published the Bris Yehuda, all the banks changed their Heter Iska. Why did they change their Heter Iska? Because the Bank Mizrahi changed their Heter Iska. They used his Heter Iska, and the other banks didn't want to lose business to the Bank Mizrahi, so they adopted the same Heter Iska. it was a Heter Iska that had Hidurim in it. What it is not my problem right now. But if you're telling me this is, religious accommodation, blah, 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 we're doing it for the benefit of the customers, why did suddenly every bank change? Banks changed because we're losing customers. They had to do it. This is, arm's reach negotiations. We lend money to Heter Iska because the clients want a Heter Iska. The clients don't get a Heter Iska, they go next door. They can get a Heter Iska someplace else. So we have no choice but to do Heter Iska. Okay, so the way that you can get around it, seems to me, is if you do as follows. The standard het iske, standard het iske is het iske of Sodom, Chatzi Mil, Chatzi Pilkodin, which means, as I pointed out last time, my money is 50% exposed. My money doesn't have to be 50% exposed. The risk of Marama Victors was cruelly exposed till the point where it converted to a milva, in which case nothing was exposed. I can make it Chatzi milva, Chatzi Pikodin, but I, Mr. Moneybags, as I call him, accept 2/3 of the risk. You've invested in the business. If there's a business loss, I will accept 2/3 of the risk. In effect, you are paying me to insure your halva. Isn't that it? What I gave you for an ASIC, it's ASIC, but I lent it to you. And I'm saying that even if you go kaput, you won't have to pay all of it. I will agree to indemnify you for 1/6 of the full amount. In return for that, you invest my money also. You're investing to be marviach, what I call the insurance premium. This extra difference between chatzi milv, chatzi pikodin, and chatzi burden of loss, chatzi not burden of loss, becomes the scharamola. Now, I think that should work for the girl also. I'm not working for a peppercorn. I'm not working for schala mola kibalti, which usually is not true in the first place. And Dos Baldin is not going to help here. Dos Baldin helps, to Besden, but Klapi Shmaya, if you didn't get schala mola, who are you trying to fool? You didn't get schala mola, you're working for the Malva. But here I'm working because ordinarily I would look for some way to guarantee my loss. I get some insurance on whatever ASIC I'm involved in. Here, you paid my insurance premium, the shlish, the machzor, via, whatever it is. That seems to me you should solve the problem with the girl also. So these are just the different kinds of heter iskas that are floating around out there. And I presume that there are others, miminim, shainim. I've seen all kinds of variations that I haven't seen anything that substantively varies from one of the kinds that I've outlined, but you can mix and match. You can do all kinds of things if you're writing a heter iska. Adkan.